now, many of you have probably seen this video.
To prep him for emergencies.
About a mom whose 7-year-old son was hit by a rogue drone during a drone light show gone wrong in Orlando, Florida, videos of which are now everywhere. Tagged in this video a couple hundred times, and I get tagged in videos like this all the time. There's a quick reminder about one of the most common misconceptions when it comes to these types of lawsuits. That is the assumption of risk, and although not totally applicable here, although maybe a liability waiver. Here's why those two things often don't matter nearly as much as companies tell you they do. The sort of same way that when you get on a roller coaster, you see the sign that says, you assume liability for any risk involved. Do you? First, as an initial matter, I can't find the contract that Sky Elements signed with Orlando, and find one they've used in the past for the city of Avon, Indiana. Well, interesting things to note. First, the damages provision saying you can't do anything to us actually appears only to apply if someone enters the unauthorized area, or anything that happens during what's called a force majeure. So long story short, is essentially an act beyond the control of the organizers. Really just saying you can't hold us liable for any damages that may result from, for instance, breaking another contract. At least as far as I can tell, there's not even an attempt to say you can't hold us liable for any injuries that might occur to, let's say, spectators. Though, to be fair, I'm probably missing that in a document that I haven't seen yet. However, it is important to note, as you'll see here during the insurance section, they hold a lot of insurance. And if you check out the bottom provision, they're also going to include things like the city as part of the insurance policy so that you can go after both. In other words, as far as I can tell, the contract that happens for these drone shows happens between the drone show company, Sky Elements in this case, and the city, Orlando. Typically what happens in these scenarios is there'll be what's called a liability waiver. But like, not to use the same name, but Sky Zone. Sky Zone, your kids are about to jump on all this stuff, you have to sign the liability waiver. Basically says, if my kid gets injured doing any of these activities, I'm not going to sue. Those people, when there's an injury that occurs, think, oh my gosh, but I signed the liability waiver. I can't do anything. However, in most of these cases, because they're personal injury, you're likely going to be suing under a negligence standard. Because of that negligence standard, there's some important questions to ask about that liability waiver. First, you got to remember that liability waiver is just essentially a contract. Because of that, you got to ask, who is actually on that contract? Go to Sky Zone, it's between me and Sky Zone, or signing by proxy for my kids. Here, any sort of liability waiver is going to be between the city, Orlando, and Sky Elements drones. There is nothing signed by this family, as they were simply watching the drone show. In all likelihood, this issue is pretty much done right here, because without signing a liability waiver, you haven't waived your liability. So you've signed a liability waiver in a different context for something else. Next question you're going to ask is, what is the scope of that liability waiver? Courts have pretty unanimously held that that scope has to be very clear, it has to be unambiguous, and whatever the negligence is that results in said injury, depending on the jurisdiction you're in, usually has to be related to the purpose or object for which the release was signed. In other words, if I go into Sky Zone, I get injured because a ceiling tile wasn't installed properly and falls on my head. In all likelihood, I'm not unable to sue because I signed a waiver. I signed that waiver for bouncing on trampolines, not for ceiling tiles. Probably most important, if a defendant's conduct is what's called grossly negligent. In most jurisdictions, even if it was a valid liability waiver, it might not matter. Again, different based on jurisdiction, but ordinary negligence is essentially you did what any reasonable person would have done, even if you didn't exercise enough care. Gross negligence is like, you were awful and you didn't care at all, or an extreme departure from the ordinary standard of conduct, which is going to change pretty drastically depending on what type of conduct we're talking about, because some ordinary standards of conduct, like probably drone flying, requires quite a bit of care and safety precautions. Ordinary standard might be very high. The second thing that most people have to overcome in these scenarios is the assumption of risk. It's kind of like a liability waiver without signing a liability waiver. More often seen in extreme sports or even high touch point sports like football. Essentially absolves the defendant of their duty of care. Theory being, if you are required to uphold that duty of care, then the very fundamental nature of whatever that activity is might be different. For instance, tackling in football is dangerous. Or to say there's a duty of care for all players and coaches to avoid getting hurt during tackling, football is then flag football, as it would change the very nature of the sport. Courts have largely said there's an assumption of risk there. Two exceptions to that, both of which focus on essentially how the defendant acted. One, when the defendant's activity is entirely outside the scope of ordinary activity engaged by teachers, coaches, players, etc. And two, where the defendant unreasonably increased the likelihood of risk over and above what's inherently involved in the activity. Example being, a coach decides to run a full football practice without helmets, expects you to tackle people just the same way. Or a coach sets up a standard by which you go after a player's head when you tackle. All those things are reasons why I say just because you've signed a liability waiver or you were involved in a dangerous activity does not mean that you don't have options. So here, for instance, although the exact documentation is obviously unknown to me, I would imagine there's going to be a pretty large lawsuit against both Sky Elements drones and the city of Orlando, potentially the drone manufacturer. Sky Elements will likely say, well, hey, the FAA told us it was fine. There's going to be a lot of finger pointing. But at the end of the day, someone got seriously injured during an activity that they shouldn't have been injured at. That usually matters more than anything else. Always keep the tags coming. I like to help people out where I can. And of course, if you have any specific questions about a situation that you're dealing with, I'm pretty easily accessible by electronic mail. And you can find that electronic mail by going to there or there, depending on where you're seeing this.